Matlala is going through hell in CMAX prison. The condition his lawyer said he is currently in has left people in shock, and even the hard-hearted are begging for his pardon. Despite all the explanations and attempts to secure bail for Matlala and his wife, the chief judge stood his ground and took an unfavorable step against them. Watch until the end to hear for yourself what Matlala is going through, and let us know if he deserves mercy or not. Please don't forget to hit the like button and subscribe for more updates.
Yes, thank you.
My Lord, let me start off by placing the following on record, and unfortunately I now have to go back to the setup in prison. I don't know if your Lordship has ever been to CMAX, but your consultations there are through a very thick glass. And you've got people around you the whole time. Unlike, for instance, downstairs in the consultation room, if you want to show documents, you can slip it underneath the wire bar that is there. We've got a docket, my Lord. We've got 3 dockets. Quite a large number of documents contained in that. Some of those documents are expert reports. We also got the hard drive from the state, and as I've already confirmed, we now managed to open it. It consists of 1 terabyte. My Lord, we're going to ask that our client be brought back here on Monday. During the adjournment, I also managed to make 1 or 2 phone calls, and I've been informed that it's going to take time to get any form, if one gets permission from the prison, to consult one-on-one with him. So I'm going to ask that he be brought back here on Monday to finalize consultations, because the expert informed me that because it's a very costly exercise, that we need to ascertain certain aspects from the client, which means that we need to sit down with him, show him what we've got, and take instructions, and then compare that with the easiest, most convenient way, because we want to get to deal with the pre-trial as quickly as possible, sort out future issues that we have, is to ask the court that we be permitted to do it here on Monday. My Lord, it's not a strange thing that happens. We've done it. I've done it on numerous times. Lots of lawyers consult down here if there is issues to consult and get instructions on an urgent basis. We are not going to make a habit of it, my Lord. We ask that it be done in the interest of justice. As I said, I believe that it's going to take a long time to have a proper consultation with the client. At least when it comes to the expert issues, we can sit with him, have direct contact with him, show him the stuff, push documents through to him that he can read, and give us proper instructions.
Now here's a full detail of what Matlala's lawyer said about his condition in CMAX, what he is passing through, and why they want him to be moved out of that place as soon as possible. South Africans, will Matlala use his influence to get relocated from CMAX? Let's see where the whole story is heading to. The legal team representing Vusimusi Matlala has raised serious concerns about access to their client ahead of crucial pre-trial consultations at Kgosi Mampuru Prison, warning that restrictive conditions could delay preparations in a case that already carries significant legal and logistical weight. The matter came into focus during proceedings at the Johannesburg High Court on Thursday, where Matlala appeared alongside his wife, Tsakane Matlala, and 3 co-accused, alleged hitmen Musa Kakana, Tebogo Thobejane, and his daughter Nthabiseng Nzama, to agree on a pre-trial date in connection with the attempted murder of Matlala's girlfriend, Tebogo Thobejane. After discussions between the parties, February 26th was set as the date for the pre-trial hearing. While the scheduling marked a procedural step forward, it quickly became apparent that the defense believes the timeline may prove challenging given the volume of evidence and expert material that must be reviewed. Central to the concern is whether Matlala can meaningfully consult with his legal team under the current prison arrangements. Matlala's lawyer, Anneline van den Heever, addressed the court directly, seeking permission to consult her client in the court cells rather than at the prison facility. Her application was grounded in practical difficulties encountered at Kgosi Mampuru, where she described the consultation environment as constrained and unsuitable for handling complex documentation. The consultations at Kgosi Mampuru are very tight, and you have people around you the whole time, unlike downstairs in the consultation rooms, where, when you have thick dockets, you can slip them under the barbed wire there. So I asked the court to allow for Matlala to be brought back here on Monday to finalize consultations, because the expert informed me that, given that it is a very costly exercise, we need to ascertain certain aspects from Matlala. This means we need to sit down with him, show him what we have, take instructions, and then compare that with the reports, she said. Her remarks underscored the scale of the case file and the practical obstacles that come with reviewing extensive material in a secure custodial setting. According to the defense, the state has provided a hard drive containing evidence, adding a significant digital component to an already substantial body of documents. Heever explained that the hard drive alone consists of 1 terabyte of data, which she indicated would require detailed engagement with her client. We have also received the hard drive from the state, and it has already been confirmed that we are now able to open it. It consists of 1 terabyte. I believe it is going to be a long consultation with the client. At least when it comes to the expert issues, we can sit with him, have direct contact, show him his material, pass documents to him to read, and allow him to give us proper instructions. If we foresee that we will not be ready, I have indicated from my side that the moment we realize this, we will inform everyone that we cannot proceed with the pretrial, she said. Her application reflects a broader tension often seen in complex criminal trials: the balance between expeditious proceedings and the accused's right to adequate time and facilities to prepare a defense. The defense maintains that Matlala is prepared to prove his innocence, but requires sufficient access to the evidence and time to review it thoroughly. The financial implications of involving expert witnesses were also raised, with Heever indicating that instructing an expert without first clarifying aspects with her client could result in unnecessary expense. The presiding judge, William Karam, responded by ordering the prison authorities to make arrangements for consultations on Monday and Tuesday. His directive was intended to ensure that the defense would have an opportunity to engage with Matlala ahead of the February 26th pretrial date. However, Karam also made it clear that the court would not allow the process to stall indefinitely. This court will still ensure that the accused's rights are respected. Accused numbers 1, 2, 4, and 5 are scheduled for February 26th, he said. The judge's stance signals the court's determination to maintain procedural momentum while simultaneously safeguarding constitutional rights. In doing so, the court attempted to strike a balance between competing interests: the need for thorough preparation on the one hand and the public interest in timely justice on the other. The presiding judge, William Karam, responded by ordering the prison authorities to make arrangements for consultations on Monday and Tuesday. His directive was intended to ensure that the defense would have an opportunity to engage with Matlala ahead of the February 26th pretrial date. However, Karam also made it clear that the court would not allow the process to stall indefinitely. This court will still ensure that the accused rights are respected. Accused numbers 1, 2, 4, and 5 are scheduled for February 26th, he said. The judge's stance signals the court's determination to maintain procedural momentum while simultaneously safeguarding constitutional rights. In doing so, the court attempted to strike a balance between competing interests: the need for thorough preparation on the one hand and the public interest in timely justice on the other. Complicating matters further is Matlala's recent transfer within the correctional system. Last month, he was abruptly moved to the Ibongweni Super Maximum Facility in Kokstad, KwaZulu-Natal, following a threat assessment. The assessment suggested that he was colluding with prison staff at Kgosi Mampuru. The relocation to a super maximum security environment inevitably introduces additional logistical hurdles for legal consultations, as such facilities are designed with heightened security protocols that can limit physical interaction and document handling. Although the current consultation request pertains specifically to arrangements at Kgosi Mampuru, the broader context of Matlala's custodial movements may influence how future consultations are structured. Transfers between facilities can disrupt legal preparation, especially when they occur unexpectedly. Legal teams must coordinate with correctional authorities, secure permission for extended visits, and ensure that confidential communication remains protected. In criminal proceedings of this magnitude, preparation is not merely a procedural formality, it is foundational to the fairness of the trial. The defense's emphasis on direct engagement with the accused reflects the principle that an effective defense requires more than passive receipt of evidence. It demands active participation by the accused, informed instruction to counsel, and strategic consideration of expert reports. The reference to expert involvement indicates that technical or specialist evidence may play a significant role in the trial. Whether related to digital forensics, ballistic analysis, medical reports, or other specialized fields, expert testimony often requires careful alignment with the accused's version of events. Heever's submission that the expert had advised clarifying certain aspects with her client before proceeding highlights the interconnected nature of legal and technical preparation. The February 26th pretrial date, now firmly set, will likely serve as a procedural checkpoint rather than the commencement of the full trial. Pretrial hearings typically address issues such as readiness, disclosure compliance, witness lists, and potential legal objections. However, if the defense ultimately indicates that it cannot proceed due to incomplete preparation, the court may be required to consider whether a postponement is justified. Heever has already indicated that if readiness becomes an issue, she will inform the court promptly. This proactive stance suggests an awareness of the court's emphasis on efficiency. At the same time, it underscores the defense's intention to avoid unnecessary delay while preserving the integrity of the preparation process. Judge Karam's comment that the court will proceed even if Matlala is not ready introduces a note of firmness. Yet his assurance that the accused's rights will be respected reflects judicial sensitivity to constitutional safeguards. The interplay between these two positions, readiness and rights, will likely shape the tone of proceedings as the pre-trial date approaches. For the co-accused, the timeline may carry distinct implications. While their legal teams were not quoted during the hearing, the scheduling decision applies collectively. In multi-accused trials, delays affecting one defendant can ripple across the entire case. Courts must therefore manage the interests of all parties, ensuring that no accused is prejudiced by another's circumstances while maintaining procedural cohesion. The fact that the state did not object to additional consultation time may also signal confidence in the strength of its case. Prosecutors often prefer to avoid appeals based on claims of inadequate preparation, as such challenges can undermine convictions long after a trial concludes. By allowing reasonable consultation, the state reduces the risk of future procedural disputes. As the legal teams prepare for February 26th, the central issue remains access to the accused, access to the evidence, and access to the time necessary to reconcile the two. In high-stakes criminal litigation, these elements are inseparable from the broader quest for justice. Matlala's legal team has framed the matter not as an attempt to delay proceedings, but as a practical necessity dictated by the scale of the evidence. The 1-terabyte hard drive, combined with physical dockets described as thick, paints a picture of a case built on extensive documentation. Reviewing such material under restrictive prison conditions presents undeniable challenges. Whether the consultations ordered for Monday and Tuesday will suffice remains to be seen. Much will depend on the efficiency of the arrangements made by prison authorities and the complexity of the issues that emerge during discussions between Matlala and his lawyers. Should unforeseen complications arise, the defense's earlier warning about potential unreadiness may come into sharper focus. For now, the court has charted a path forward. Consultations will proceed, the pretrial date stands, and the rights of the accused are to be upheld. As the legal process unfolds, the coming weeks will determine whether preparation keeps pace with the demands of the case or whether additional adjustments become necessary.